The first matter to come before the court this morning is State of Ohio versus Christopher Shinholster. The state has waived oral argument, counsel. You have 15 minutes to present argument this morning. We have read the briefs and we're ready to see when you are.
Thank you, Your Honor. May it please the court. Jennifer Cundiff on behalf of Christopher Shinholster. Your Honors, we're here today for the presentation of the appellant's brief and the oral argument on the appellant's brief. In my brief, Your Honor, I raised 3 assignments of error. This appeal is being brought by the Summit County Court of Common Pleas Trial Court. The procedural history associated with this case is lengthy. Would the court like a recitation of the procedural history associated with this case?
I think you laid it out fairly well in your brief, or very well in your brief, so I think we can move forward to your assignment of error. Thank you.
Thank you, Your Honor. The issue before the court today is what is the proper remedy for an allied offense sentencing error when that is remanded from a habeas corpus petition that is granted by the federal district court. Your Honor, the trial court held a hearing, which it characterized as an election hearing, where the defendant appeared with the prosecutor and the judge vacated one of the sentences. The judge allowed the state to decide which of the 2 offenses to vacate, and in this case, he vacated the possession of cocaine charge. Your Honor.
Did I understand you to say that the judge allowed the state to elect?
That's correct, Your Honor. If you look at the transcript, in the transcript, the prosecutor characterized the hearing as an election hearing. And I believe that the judge actually uses the term that if the state is going to elect to not proceed on the possession charge, then that she would vacate that charge. So
why isn't that wasn't clear, at least to me, from the briefs. Why isn't that sufficient where the judge allows the state to elect which count to proceed on?
Well, Your Honor, in State v. Whitfield, the Ohio Supreme Court set forth the procedure that a trial court is supposed to undertake when they're remedying an allied offense sentencing error. And that procedure was further explained by State v. Wilson. And in both of those cases, the procedure is very clear. First, the state elects which of the 2 offenses to proceed upon. At that point, the defendant is then entitled to a de novo resentencing hearing. It's essentially a 2-part procedure. The reason for the 2-part procedure is because the statute that was enacted by the General Assembly and then interpreted by the Supreme Court in those 2 cases, they state that double jeopardy in due process states that you cannot have 2 of the same convictions. Conviction means that there is a guilty finding and a sentence. If you have the guilty finding and then proceed to sentence on both of these and simply allow the court to unilaterally dismiss one or the 2 offenses, you're not remedying the double jeopardy issue.
Well, how did the court unilaterally dismiss it when it asked the prosecutor to elect?
Well, it asked the prosecutor to elect, but it missed the second part of the test and the procedure. The second part of the procedure allows the state to elect, but then the defendant has the right to have the sentencing hearing on only one of those guilty findings. Because the state moved forward now on essentially 2 of the guilty findings at the sentencing hearing, and the sentencing hearing was not done de novo, those 2 sentencings, they can impact each other. They're interdependent. In 2010, when the sentencing occurred, it was on those 2 offenses. Mr. Shinholster was never afforded the right that he has to only have one of those cases heard at a sentencing hearing. That's a right that he has based on the Constitution, his double jeopardy right. So when the court allows the state to have their part under the procedure and say, I get to elect which of the 2 we're going to move forward on, but then says you don't get a new hearing, they're essentially denying Mr. Shinholster his right to have the sentencing hearing only relied on one of those offenses. Because the hearing that was held in 2010 was considering both the possession and trafficking charges.
How's he prejudiced where the court in 2010 held the sentencing hearing on both? I could understand your argument, I think, a little better if the trial court only heard sentencing, if these issues were reversed. Mm-hmm. The trial court only heard sentencing on one, and then he appears several years later, and there are 2 counts now. And he's never had an opportunity to present evidence with respect to the other one. But what's the prejudice to him where there was a full hearing?
Well, Your Honor, I believe that the prejudice is in that the judge is now considering him as being in violation of 2 Ohio Revised Code statutes as opposed to just 1.
How do we know that? What makes you think that?
Well, because at the hearing, he was found guilty of both of these offenses, and then the state moved forward in the sentencing hearing on both of these offenses. So because the court is looking at both the possession charge and the trafficking charge, there's no way that we can know that she didn't consider the fact that he had 2 offenses versus 1 offense in her sentencing decision. There's not anything to suggest that she, decided that these are essentially the same charges, so I would have given him the same case anyway. We don't know that. So without knowing that, he's entitled to a de novo resentencing hearing. The only way to protect his right against double jeopardy is to have that resentencing hearing where the court can then consider only 1 of these offenses. Because there is no order that was issued by the court that said, well, I consider, this offense to be higher weight than this offense. We don't know. And because we don't know, we should err on the side of caution in protecting Mr. Shinholster's rights. And I think that the trial court also erred on the side of protecting the state's right. It allowed the state to do an election. And the state's entire brief argues that this trial court was merely following the order of the federal court. If you look at the order of the federal court actually appears to suggest a unilateral change of this sentencing. It actually says that within 90 days an entry shall be vacated. So if you look at the state's argument strictly, what the state is essentially arguing is that the trial court should have chosen which of the 2 offenses to have, not even brought Mr. Shinholster back for any sort of a hearing, made that change and moved on. But that's not what happened here. What happened here is that the trial court allowed the state to decide which of the 2 to move forward on, step 1 of the process, and then didn't go to step 2 of the process and said, we don't get a resentencing hearing. Instead, I'm just going to vacate the one that the prosecutor chose, and I'm going to find you guilty of that offense and reimpose the same exact sentence. Now, when we look at what the de novo resentencing hearing would mean, Mr. Shinholster was originally found guilty and sentenced before House Bill 86 went into effect. If he had a de novo resentencing hearing today, House Bill 86 would clearly apply, and I don't think the state refutes this. The state instead argues that there was no error here, that the trial court acted appropriately in not allowing Mr. Shinholster to have his de novo resentencing hearing. I don't think that anybody is denying the fact that the case law is very clear that if Mr. Shinholster has not yet been sentenced and House Bill 86 is in effect, House Bill 86 would apply. House Bill 86 changes the way that an MDO specification is applied. And in this case, Mr. Shinholster would be serving a mandatory 11-year sentence as opposed to a mandatory 10-year sentence with a 5-year non-mandatory MDO.
And that's really what this case is about.
Absolutely. That's really what this case is about. Is if Mr. Shinholster was sentenced today, he would be serving a mandatory 11 years as opposed to the mandatory 10 years plus the 5 years under the MDO. Regarding my last argument, Your Honors, that involves the continuance that was denied by the court. Mr. Shinholster did not have an opportunity to talk to Attorney Laybourne prior to that case. Attorney Laybourne asked for a continuance so he could review the motion that was filed pro se prior to him being appointed as Mr. Shinholster's counsel. At a minimum, that should have been granted by the court so that Mr. Laybourne could have potentially filed another motion to kind of inform the court as to what the proper procedure is here, especially considering this is a very unusual situation. It's not very often that we see a habeas corpus petition returned from the federal district court when we're trying to figure out how we need to proceed and what the proper procedure is. I think that granting that continuance would have at a minimum allowed Attorney Laybourne to read the motion, become informed, and argue more forcefully that a resentencing hearing was required. The reason I'm arguing this under plain error is it's not clear from the record that there was any objection to the denial of the resentencing hearing. Mr. Shinholster states many times that he believes he's entitled to a resentencing hearing, but his attorney doesn't actively object. And I think the reason for that is because Mr. Laybourne was not given an opportunity to even review this case. And if you look at the habeas corpus petition, it's 800 and some pages long. At a minimum, a continuance so he could review the record, review the procedure, and figure out what the proper outcome would have been appropriate in this case. So, Your Honors, at this time, we believe that we have appropriately laid out what the proper procedure should be in this case, that Mr. Shinholster is entitled to a de novo resentencing hearing, that at that de novo resentencing hearing, House Bill 86 would apply, And by virtue of that application, his sentence should be drastically altered. Your Honors, we ask the court to find in our favor, to reverse the trial court, and to remand. And Your Honors, I would like to note that had this case originally been argued that there was an allied offense sentencing error, which that was not done, and that's why the habeas was granted, Mr. Shinholster would have been afforded this procedure. The state does not deny that. No case law denies that. If this was a remand from this appellate court, he would have been afforded the election by the state, and then the de novo resentencing hearing. The state seems to argue that because it's coming from the federal court, the procedure should be different. Your Honor, I think that that clearly implicates a due process issue as well. And that is a substantial right that Mr. Shinholster has that plays into the plain error argument that I've already raised in my brief. Thank you.
Thank you, counsel, for your presentation this morning. The court will take the matter under advisement. We will issue a written decision, which will be mailed to both parties as well as posted on the Supreme Court website. Thank you.